Jud A and call that up. I will be jumping around the agenda. We also will be adjourning before 3 o'clock. So we'll be adjourning it, or we'll be recessing this committee if not adjourning before 3 o'clock. So we'll go, the first one will be Senate Bill 2744, Community Mental Health Centers. Going to turn it over to Senator Boyd, who's worked long and hard on that, and let her explain the bill. Can you pull the microphone?
There's been a number of hearings in the Senate and the House over this particular issue. It's an issue I know our chairman spent a good bit of time this summer looking at. And so what we have in here is we need to get the mentally ill out of our jails. And so we have a process here that we've worked with. Basically what happens is before somebody is able to take out an affidavit, prior to them taking out an affidavit on someone, they are going to work with their community mental health center. They will do a pre-affidavit screening on the individual when possible. If they can't do it, they're going to make notations as to why they can't do that, why it's not feasible, but they also are going to talk to relatives or anyone that really is trying to get this affidavit filed. They have to do that within 24 hours. If the community mental health center is not available, the judge, there's some authority to appoint somebody to go get this done. If after they do the pre-screening process, they find out there is cause that this person does need to be committed, they'll start that process. But this process is really there to ensure that those that can go into counseling, that can work with our community mental health centers, those that don't need to be put in that process, that we really work to make sure that we ease that process and get those that don't need to be out of confinement. So anyway, they'll go through that process. After the pre-affidavit screening is complete and received, upon filing of the affidavit, the commitment, the clerk will issue the writ directing the sheriff to take the person into custody for examination and treatment. Within 48 hours, the healthcare professionals appointed by the court will examine the person. And then with 3 days after the examination, the judge will decide whether a treatment in a state behavioral program or an out program is necessary and issue a commitment order. What this process does it makes sure that basically you have to look at our crisis intervention centers, you have to look for our state hospital, you have to look at all alternate forms before you put someone in a jail. If there is just absolutely no shape, there's no place else to put them for that moment, it's safe. Basically, they have 24 hours to secure another place to put them. This is incredibly important. If you've read the articles this week, the state is facing litigation because we are continuing to put those that are mentally ill in our jails, and I think this will go a long way in making sure that we work through this. The Department of Mental Health has very much worked with other states looking at their commitment process, and they have worked with a lot of other states, particularly looking at Tennessee. They've interviewed a lot of them as to what are the best processes to be used. So that is kind of the nutshell in that. The additional thing that we've done too is we've actually made some suggestions on our community mental health centers. Many of y'all know that the state was embroiled in litigation several years ago in regards to our mental health system. And basically what we've done is we've put some procedures in place where our community mental health centers would be subject to audits. Their performance audits, looking at what they do, very similar to our school districts having accountability metrics in that. We've also put some provisions in here. We've had complaints. We worked with the Board of Supervisors and the Sheriff's Association on all of these procedures, and also making sure the Board of Supervisors really taking an active role on what is going on at the community mental health centers. They'll report quarterly to them. There's no new metrics that we're requiring them to collect or anything. These will be things that they've already collected, but they'll report it monthly to the Board of Supervisors. We have also put some financial issues in here, trying to make sure they have a cash balance of 6 months of operating expenses. Also too, if they are failing to comply right now, the Department of Mental Health, they basically have two options when they see that a community mental health center has issues. One of those options is to take away their funding that the legislature gives them. The only second other option is to decertify that and basically close it down. So there's no remedial steps that can be taken with that community mental health center. This puts a remediation plan in place with procedures that the Department of Mental Health can do and really work with our community mental health centers to strengthen them and make sure that process is stronger. So that is a lightning speed going through that bill. I'm happy to answer questions.
And thank you. And I will say, if you're on the Public Health Committee, we spent the first part of the session having hearings. We heard about these issues, and, you know, there's been a lot of reporting on it. So Senator Boyd has done a lot to address that. And this is the vehicle by which we are trying to address these issues that we've been seeing. So with that, I'll open it up to any questions. Senator Kirby.
Well, thank you, Mr. Chairman. I had someone question me here on the director's salaries in that bill. I mean, we've had like a director for 27 years.
I'll let her answer it, but during the Public Health Committee, and I think I was responsible for that, but what came out in the Public Health Committee was the great disparity of salaries amongst community mental health centers, to the point where there's some making $380,000, while there are community mental health centers that are going under, including in South Mississippi. And I'll just use the area I'm from. He was making $300,000+ and they're have issues. And so then Senator Boyd did an analysis, and as did Chairman Creekmore from the House, and let's just say it raised some questions. So
Yeah.
I'll bet if she can answer.
They can make up to over 20% of what the state mental health director does, and that would be a salary cap of $215,000. So because we have salary ranges of the different community mental health centers, we have salary ranges from $100,000 to almost $382,000. So we have wide discrepancies in these salaries.
All right, and one other issue that was one said this is a coast problem, not a problem in this part of the state. Is that a coast?
That's funny that they say that, because, and please forgive me, but that's ridiculous. Okay, this is a statewide problem, and yes, South Mississippi has had its issues, but I think Senator Boyd can tell you what others. So, you know, I'm happy to talk to that person who says it's a coast problem. It ain't a coast problem.
We've had community mental health centers that in the last number of years who've had to merge with other districts because they've closed theirs down. This really places the opportunity for, and I think probably if we had had some of these metrics in place, some of the ones that were open could have continued to stay open because they're bored and they could have worked with them and their metrics. And that, so I think this is a good opportunity, and I think the corrective measures are here in place. So hopefully that we can have them thriving and staying strong.
Thank you, Senator Kirby, and that's a fair question. But we sat for 2 hours through public health hearing these issues. So appreciate it. Thank you very much. Senator Barrett.
Thank you, Mr. Chairman. How many community mental health centers are we talking about, Senator Boyd?
11.
Okay. Okay. And when we're talking about these mental health centers, are we talking about like Region 8 or Region 5? Ones that are already in place, we're gonna add on to those, is that correct?
Adding on, this is about really looking at the system that we have in place right now.
Okay, thank
We
you.
know there will be another new one formed in one of the coastal counties.
Okay, any other questions? All right, do I have we do have a committee substitute, proposed committee sub? No, we're on the bill itself. Do I have a motion? Huh?
It is a committee sub.
Okay, committee substitute.
Yeah, motion to adopt committee sub.
Motion's to adopt the committee sub. All in favor, say aye. All opposed?
Motion to adopt committee sub, motion to adopt committee sub on final passage.
Final passage. All in favor, say aye. All opposed? Okay, that one carries. Thank you very much, Senator Boyd. Appreciate that. All right, we're gonna go to Senate Bill 2260. Senator Barrett. I will just state this is a simple bill, creating, standards for our public defenders. And Senator Barrett, I think Senator Barrett has a motion on.
I do. Mr. Chairman, at the appropriate time, I'd like to motion in line 29 that we remove the word enforce. So the language of the bill would read, the state defender shall promulgate and implement standards that define how effective indigent defense services should be provided in all such cases. So that would be a motion to amend, and that amendment would remove the word enforce.
Okay, before we vote on the amendment, can you explain what it's doing?
Sure. So essentially, the State Public Defender's Office, I believe we have Mr. Andre Degree in here today. The State Defender will be empowered to essentially promulgate, implement rules so that all public defender offices are acting consistently and with uniformity. Now, each public defender's office, the way I understand it, Lincoln counties may be different than Capiz County's defender's office, which is different than Hines County. So I think these rules that will be implemented and developed by the state public defender's office is an attempt to be transparent and an attempt to have consistency across the state of Mississippi for effective indigent defense.
And this has been requested by the state defender's office. Okay, so we're on the amendment. So all in favor of the amendment, say aye.
Aye.
Opposed, the amendment carries. Okay, we're on the bill, we're on the committee sub as amended. I guess it is a committee sub. So question? Okay, any questions? Okay. Simmons?
Thank you, Mr. Chairman. I know you've adopted the amendment, but I was just curious. I serve on Senator Barrett's subcommittee, and in committee, if I'm not mistaken, we had already made that amendment. So I was just curious, when we actually pass something out of subcommittee, does it come back to the full committee with the amendment from the?
No, it should, yes.
Okay, all right.
That was, put that on me. We were trying to make that the case.
Yes, sir.
The materials before me, I didn't see that. So
Thank you, Mr. Chairman.
I'll get with council, and either it's the amendment that he made reflects what the subcommittee.
Yes.
That's correct.
All right, any other questions? All in favor, say aye. All opposed? That was on a motion title sufficient due pass, in case you didn't know. All right, we are going to, Senator Johnson is here. We're gonna go to Senate Bill 2130. And I'm gonna let Senator Johnson explain the bill. From a legal perspective, it's a simple bill to, there's a movement to cancel insurance if you don't have 10-year shingles. And this really sailed through subcommittee. But I do understand that Senator Johnson has worked with Senator Kirby on an amendment on that. So if you'll explain the bill, Senator Johnson.
Yes, so the bill states that an insurance provider cannot um, deny coverage or not renew coverage for a roof that is 15 years older or older. And it provides that if one is above 15 years, that the homeowner can, at their own cost, get a roof inspector, an authorized inspector, to look at the roof, and if they say that it has at least 5 years of useful life remaining, that the insurance provider cannot deny coverage for that. We did add from the subcommittee, in this committee sub, that, that the roof, that the insurers have the option to insure at actual cash value or a depreciated cash value. And it also gives the commissioner of insurance the option to exempt certain areas, for instance, the wind pool area on the coast if necessary. And the idea behind this is that there's many people who go to buy a home, say, and when they get close to closing, the insurance company says, well, we're not going to write this because the roof is is older than what we would like to write it at, and say that's at 12 years and the roof was replaced 15 years ago. But the roof is still in good shape. It could have 30-year shingles. And so people get to closing, and unless they have the amount of cash to redo their roof, or if they can borrow extra money to do that, they don't get insurance, can't close on the house with financing. So that would solve that problem. I've talked with some of the insurance companies. They like the language in the committee sub better. They're not totally in support of it, but it is a good bill for consumers.
And I would say that the proposed committee sub that's in your packet, that reflects the amendment that they had worked on.
That's correct. Yes.
And we'd heard, had been in communication with the insurance companies and all that. I appreciate Senator Johnson working to get this amendment there. To address it. So any questions? Have questions on that? Okay. Have a motion? Motion is title sufficient to pass. Committee substitute. All in favor say aye. All opposed?
Thank you, Mr. Chairman.
Thank you, Senator Johnson. All right, we're going to go to item Senate Bill 2822, which is Senator Sparks. It's simply the code sections for the Administrative Office of Courts. There has been there's some issues in terms of working with them and getting funding. We've had a number of, people that have questioned how certain things are being done with the intervention courts and all that. And these code sections are simply being moved forward to allow us to address that. With everything that's going on with courts this year, we've been in contact with the AOC and the court, and we'll continue to do so. So I have a motion on that one. Motion's title sufficient to pass. All in favor say aye. All opposed? Okay, moving along. I'm going to call up Senate Bill 2530. And it says on your agenda, this is the peer-to-peer car sharing program. I will note that this has come to us from insurance, and the insurance issues were discussed and addressed there. And so would ask that, certainly can ask the questions, but just know that the insurance part of this was addressed through the insurance committee. And the peer-to-peer, what this is, if y'all recall from a number of years ago, we did the legislation that allowed for Uber to come in. Well, this is similar, except it is car sharing. And I think there's coming into Oxford. Is that right? Are there places coming into Oxford? Oh, I'm sorry. Didn't see you. Please introduce yourself to the committee. Sure. That's good. And yeah, so if the insurance issues have been worked out, and so the liability, and so they're here to answer any questions. Toro is the company that's asking for this to assist, and it can also, I guess, create the market, if you will, for other such sharing programs. Is that right? Okay. So the bill's in front of you. Do you have any questions on Senate Bill 2530? All right, do I have a motion? Senator Boyd? Title sufficient, do pass is the motion. All in favor, say aye. All opposed? That carries. Thank you very much. That'll go to the floor. Appreciate what y'all are doing on that. So, thank you. Okay, I'm gonna get Josh. We have an add-on to the, keep wanting to say docket, it's the agenda. And Senator Harkins is here to present Senate Bill 2753. You have in front of you what you have. That's, we have the committee. We're gonna, we'll move, we're gonna hold on to that. We can get that. Of this one? Oh, look at you. Thank you very much. That's where it is. Sorry. That's why it's an add-on. Okay, so you have before you, it's Senate Bill 2753, and attached in your packet is the proposed committee substitute, and authored by Senator Harkins. And this is the Securing Areas, the SAFER Act, Securing Areas for Females Effectively and Responsibly Act. And I'm gonna let Senator Harkins speak to it. I will state that the committee substitute before you is simply addressing state property, and particularly your universities and colleges, and is addressing how those spaces are to be laid out. And so with that, I'm going to turn it over to Senator Harkins.
Thank you, Mr. Chairman. Beginning with Section 3, it has definitions that describe what changing facilities, single-sex educational housing spaces are, public building, restrooms, unisex changing facilities, unisex restrooms, gives definitions of all those. Section 4 just addresses the protection of restroom privacy. Any public building that maintains a restroom shall at a minimum have a restroom designated for exclusive use by females and a restroom designated for exclusive use by males, or a unisex restroom. Section 5 provides for the protection of changing room privacy, that just says that any public building that maintains a changing facility at a minimum must have a changing facility designated for exclusive use by females and exclusive use by males, or a unisex changing facility. Section 6 talks about the protection of single-sex educational housing space, that any student required to reside in housing at an educational institution shall have the right to be housed in a single-sex educational housing space with persons of the same sex. Section 7 addresses social fraternity and sorority single-sex housing facilities on public lands. The Section 8 talks about permissible purposes to enter sex-designated restrooms, changing facilities, or single-sex educational housing spaces. Most of these are kind of common sense, laid out to accompany a person of the opposite sex for the purpose of assisting or chaperoning a child under the age of 12 or vulnerable person, or a person with a disability, for law enforcement, fire protection, response, or other public safety purpose, for governmental purpose, including employees, contractors of governmental entities acting within the scope of their employment. That would cover coaches that may coach an opposite sex sports team, that will allow them access at the appropriate time. for the purpose of rendering emergency medical assistance to intervene in any other emergency situation where health or safety of a person is at risk, for custodial maintenance or inspection purposes, to provide that the restroom or changing facility is not in use. It also deals with the appropriate designated restroom or changing facility is out of order or under repair, and the restroom changing facility designated for the opposite sex contains no person of the opposite sex. And then in single-sex educational housing spaces as authorized by educational institutions for moving, visiting, administrative health, or other authorized purposes. Section 9 is the enforcement. As listed, Section 10 also has the Attorney General can bring action to enforce compliance with the act. Section 11 is the definition of female and male, and also sex as related to the act. You can read those there, and then that's really an explanation of the bill. It's kind of laid out to define what it is and who's allowed into which facility, which of those facilities.
Thank you, Senator Harkin. And I will state that, this committee received a number of bills, let's just say of this kind, and so this represents what I think is a good, version of trying to get this issue addressed and before the people. And with that, I'm going to open it up to questions. Anybody have any questions? Senator Hobson?
Thank you, Mr. Chairman.
Finance versus creation.
Thank you, Mr. Dude, thank you. I'm generally supportive of this, but I do have one question as I was reading through, and this may be different. I was reading through the original bill first and not the committee sub, so I'm trying to quickly compare them. But one situation that I thought about as I read this, where it talks about the sex is identified based on their biological birth,
Yes.
condition. So if you had a situation where somebody has already had a sex change operation, we know those have taken place. And so you've got, let's just say for argument's sake, you've got a male that now has had biologically changed to be a female. Would they be in violation if they walked into and this happened 10 years ago, whatever, if they walked in, if this bill passes, into the female bathroom at that time, or would they have to go into the male bathroom because their biological sex?
I believe it would be that they would be in violation of the act as written.
So if your daughter or my daughter was in the bathroom and or let's just say someone that walks in that appears to be a male and they didn't like it and they reported that, but the person, would they have to walk? They would be in the right place if it was based on their biological sex, if they had switched to the other one. I know this would be a rare incident.
Well, if it's biological sex, it may be the sex, the physical sex, because if you said they've had gender.
Yeah, that's the point I'm getting to. Is it based on their gender reassignment or is it based on their biological?
Based on biological. It says on line 173, the following additional provisions apply to the use of sex in related terms. There are only two sexes, and every individual is either male or female. Sex is objective and fixed. Persons with with DSD conditions, sometimes referred to as difference in sex development, disorders of sex development, or intersex conditions, are not members of a third sex. And so,
And Senator Hobson, I would point out on line 160 and in 160 and line 164, it uses the word naturally. Female means an individual who naturally has, and male means individual who naturally has had. And I think that helps describe that as well, which I don't know, I would argue that's probably the same as biological, but it says natural.
Yeah, I could just see someone wanting to test this case and test this statute, and I'm trying to get ahead of it, and I think the thing that I want to be.
Verified at birth.
Okay.
That's what I think that would, what the statute would say would be.
So that if let's just, again, using that hypothetical, if it's a born biological male, but converts to or born female, let's say, and converts to male, they would have to walk in the same bathroom that your daughter and my daughter would go into. Okay, thank you.
Senator Simmons?
But they were born at birth. Correct.
And I will state that, when I say we, Senator Harkins in preparing the proposed committee substitute, have communicated with the leaders of our higher institutions. Also, there has been discussion. And the point is that there needs to be guidance, because what we, and Senator Harkins can expound on this, what we're hearing is these institutions there's a lot of the word sex, male, females in the code, but there's no guidance. And so that's leading to a lot of questions. And so, to your point, Senator Simmons, that with this, should this be enacted, then there's guidance. Senator Hobson's point, yeah, there may be, I think we'd be silly to think there wasn't going to be a challenge to this, but there's guidance to the school district, not just school districts, but to the universities. And there'll be, if it passes, there's something in the law that they can refer to and guide them, because right now what we've heard is there's not. And I would say on the university's side of this, it really kind of puts into code what they are doing as they see it. Senator Harkins, is there anything else on that?
Well, I would say, what are they gonna be in 2028? What are they gonna be in 2030? What if they change back? I mean, I understand your concern. I do.
Senator Turner Ford.
Thank you, Mr. Chairman. My first question is, going over to line 98, protection of single-sex educational housing space privacy. What type of student is required to reside in housing in an educational institution?
What line did you say?
It's 99.
98, 99? A lot of colleges require freshmen to live on campus.
I didn't know that.
I can vouch for that. My daughter's a freshman and they required her to live on campus.
Yeah.
In the state of Mississippi?
Yes.
I didn't know that. Then my second question is, who is the cause of action against?
I believe it's against the individual.
You want me to take?
Yeah, go ahead. Counsel, go ahead.
And where, I was trying to find it and I
Yeah.
just couldn't.
So,
141.
okay, so there's a couple, if you look at, there's a private, in section 9, there's a private enforcement where a person can assert, I'm only using this as an example, but let's say this, in violation of this, there's a female and a male enters the bathroom and something, that female has a private right of action against that male individual. That's a private cause of action. Now, that goes along with that is damages, and we all know as lawyers, there's intentional infliction of emotional distress or anything like that. But the bottom line is there is a private cause of action. And then you have in section 10, you have the Attorney General shall bring in an action to enforce compliance with the act, which what that means is, I'm only using this as an example, if there's repetitive somebody's doing repetitively, they can seek an injunction under the current rules that we have to stop that action. That the Attorney General can do that and seek that. Also, as a matter of fact, now that I think about it, a person, the private action could actually probably seek an injunction as well. So in addition to a damages, you could seek a injunctive relief on that.
So there would not, this bill, if enacted into law, would not create a cause of action against the institution or the public facility.
So if you, and I should have mentioned this, that if you look at line 141, a violation of in a judicial or an administrative proceeding. So I would submit to you that through the various institutions of higher learning and their procedures, you can cite this act as a reason to enforce that against them. So there's multiple ways that you can address this. But if your question, can you sue them? I think the question is yes, but then you get into a whole bunch of stuff about the Tort Claims Act, and you get into a whole bunch of all the legal items that you get into.
So wouldn't that, if the facility has provided a male restroom and a female restroom, I mean, are we forcing them to basically jump in front of someone if someone tries to use the wrong restroom? Is that the onus that we're putting on these institutions by passing this?
Well, I think we're trying to provide protection for people in spaces that they would assume they have privacy. And if somebody is using the restroom that's not supposed to, then they can either go to the administration and let them know that there's somebody that's doing that, and they can have them removed. They can ask them to stop doing that. But, I mean, at some level, if you're protecting safe spaces for people, then that's what is involved in protecting safe spaces. If you have a public restroom that's multiple stalls, you would have the assumption that this is an all-female restroom, then, I mean, I think that's the purpose of the bill, is to say the expectation is that I'm gonna go to the restroom, there are gonna be all females in it, or if I go to the restroom, there are gonna be all males in it.
Now, I understand that. I would not want to be in a mixed restroom with a male person.
I don't blame you.
But
I've seen
I think that the question becomes, how is this enforced? And it almost seems as if I can't even tell you what I'm thinking. I don't want to say what I think, but it just does not seem like this is something that is practical to me. But that's just my.
Yes, I would answer it this way, in that would defer to the attorneys. If this passes to the attorneys who represent those institutions and say, y'all need to be complying with this. And then if you're not, then somebody, a private individual, or the Attorney General, as laid out here, can seek an action to enforce that, either be by injunctive relief or a private action. So, Senator Hobson.
Well, now, thank you, Mr. Chairman. I think Senator Turnford's got a point. Let me make sure I'm clear. We're not proposing in this legislation that we're going to put our state institutions, for instance, on being subject to lawsuit. This is against the individual that's walking into the restroom wrong way. This is not against our institutions. And if our institutions have a sign up on the door that says male or female or unisex, then that's the notice they've given to everybody. So if in fact we're trying to protect, I think what Senator Turnford is getting to is, our institutions got to stand outside the restroom and go, no, we're going to put people in front of every restroom and say, no, you can't enter because you don't look like a male or a female. Well, that's opening up Pandora's box, and I don't think we want the institutions. I don't think that's what's intended by this. But if in fact that there's any concern, I would propose, I don't want to, mess up the bill in any way, but that we identify plainly that it's not against the institutions, and that they're not going to be, the public body's not going to be liable for this. If I'm understanding it, there may be some other provisions I'm trying to read and digest this quickly.
I think you're right. As been explained to me, the intent is the private action and for the Attorney General to enforce it through her means.
Would it be helpful to the bill if we put in a sentence that it's not intended to create a private action against the institution? Or I guess, is this public and private?
Actually, this is only applying to the public institutions. If you look at the definition. Let's see. Public building, public university, community, junior college, and institutions of higher learning.
Would that, I'm asking, I mean, I'm willing to offer that amendment if that doesn't do anything to, inhibit. I'm in agreement with the principle of the bill, but I also want to tighten it up, because I see, look, I mean, I see a lawsuit coming out of this somewhere. And I think that as tight as we can get it, the better we're going to be.
I think the chair would certainly be open to that.
Then that would be my motion.
Okay, can you restate, there's an amendment?
That there's no private right of action created against the public institution.
Okay. Well, if I may clarify, when you say private right of action, you're talking about suing the institution?
Correct.
Wouldn't that kick in the, Tort Claims Act and all that stuff?
Well, the Tort Claims Act is going to limit, the amount of damages, but I don't know that it limits the right to proceed against them. It might limit it in some way, but I just would want to be clear that the institution, by somebody walking into the wrong restroom, going into the restroom they shouldn't be going into, that they're not going to sue the institution. They're going after the person that's walking in. I think that's the intention of this bill.
Any questions on the amendment?
And Mr. Chairman, I'm happy if I'm looking over at council, if there's some concerns that I'm not thinking of, this is flying by the seat of my pants. It's got a reverse repealer anyway. Okay. Then
Well, there you go. Sorry. Oh, okay.
thank you.
Repeat that again, Ethan, please. So, Senator Hobson. So the enforcement, for lack of, if, should that pass, the enforcement is through the Attorney General, well, against the person, not against the institutions. So y'all have heard, we're on the amendment. The questions on the amendment. All in favor of the amendment, say aye. All opposed? Okay, the amendment carries. We're back on the, as amended, Senator Simmons. So, as the committee substitute was being prepared, the intent was that it would not to our counties and cities. Well, if you look at line 61, public building, and it talks about public university, community or junior college, or the institutions of higher learning. As in preparation, that was the intent. All right, any other questions? Blackman, Senator.
Thank you, Mr. Chairman. So is this bill requiring them to put the words male, female, and unisex outside the bathroom?
There's nothing,
Or just designate that say, this is the male bathroom, this is the female bathroom?
as written, there's nothing in here that's saying, that's mandating that be put up there.
So if it's not, how is somebody supposed to know?
I think as a matter of policy, I think all restrooms are labeled for ADA requirements and other, building code related matters. I think that designating a bathroom is part of it. I mean, they have to designate a male and a female bathroom when it's a public, when it's, more than one stall. If it's a private room, it would be classified as a unisex room, and it could be male or female that time. It doesn't really matter.
So how would that work in the single-sex educational housing space? You said if it's a single one, then it's male, unisex.
I don't think I mean, if you're gonna be, if you're gonna be required to reside on campus, the university would have to provide a single-sexed housing option, single-sex space for you to live in.
Well, this is,
You couldn't force a female and a male to live together.
well, this also includes sororities and fraternities. So in the fraternity, do you just say this is the male bathroom? Because you said if it's single, then it's unisex.
Well, if it's a single stall that's locked by a door, like it says in the, definition section, if it's a single stall that is wall to ceiling, walls from floor to ceiling and locked with a lockable door, it's a unisex. Either sex can use it. If it's public, there's more than one stall, there's multiple stalls and or urinals, it's a public restroom. It has to be designated male or female.
So all single-stalled bathrooms in a sorority house are unisex, based on that definition?
And if it's a public restroom, there's more than one stall, it'd have to be female or male. If they offered a male restroom in the sorority house, which I think most of them do, it's a designated restroom that may have one or two stalls, or if it's a single stall, if it's a single restroom, it can be unisex. It doesn't have to say male or female. It can just be a restroom sign.
Well, that answers my question as well as it can answer, on that one. But on a follow-up what was said earlier, are you aware of anyone that's had multiple sex changes?
No, I'm not.
Well, the response to Senator Simmons, well, what are they gonna be in 2028 and 2030? So you're not aware of any?
I mean, there are people who have transitioned back from, yes, I've heard of it. I met, an individual last year that came here and did it, but they changed their mind to change their sex to the sex they're claiming to be on that day. What's to say they can't change their mind and want to transition back to the other sex?
Okay, and then there was a couple comments that, yeah, this law may be tested or challenged, and it was also in response to Senator Simmons. And those people wouldn't be testing or challenging the law. The law would say that if a person that was born a female, that after this law was passed, well, before the law was passed, was already transitioned to a male, they would have to go into a female bathroom. That's not testing the law, that's complying with the law. And I'm just saying that to say that this is gonna affect very few amount of people. And even if we disagree with people, we should be careful with how we talk about them because they're still people. And I just wanted to make that comment.
Thank you, Senator Black. Okay, do I have a motion? Motion is title sufficient, due pass committee sub. All in favor say aye. All opposed? The ayes have it. Thank you all for the good discussion on that. We got 5 minutes. I'm gonna, looks like Senator Seymour stepped out. I'm gonna call up, Senate Bill 2269. That was passed through the subcommittee. Actually would ask for a reverse repealer on that. Oh. Oh, okay. I think you're a co-author on it. Would ask for a reverse repealer, but yes, you're welcome to explain it. Okay, so go ahead.